Welcome to the Star Chamber. I'm Ryan Swayze, a retired Air Force Lieutenant Colonel and the founder and president of the Walk the Talk Foundation, a nonprofit that advocates for and advises currently serving and former military service members going through the arduous journey of administrative processes and investigations in our government.
And I am Francescagraham, a retired Army Lieutenant Colonel and the Chief Operating Officer and Chief Advisor for the Walk the Talk Foundation. For all our returning guests, welcome back. And for our new listeners, thank you for tuning in. Before we begin this week's topic, please do not forget to hit that subscribe button, check out our Walk the Talk Foundation website, and hit that donate button if you think we're doing a good job. Also, check out our newsletter, the DoD Times Redacted, on all the socials, including LinkedIn, X, Instagram, and Facebook. Links in the description. All right, Star Chamber listeners, let's get started. Welcome back, Star Chamber listeners, to another great episode of the Star Chamber. Today, we are very honored to welcome Robert Butch Bracknell. He is an international security, innovation, technology, and public procurement attorney and ethics and compliance professional. His experience includes employment as counsel with a regional law firm, as an assistant legal advisor at NATO's headquarters for the Supreme Allied Commander Transformation in Norfolk, practicing in the areas of international business, ethics and compliance, anti-corruption, institutional governance, and innovation law, and as a Marine Corps lawyer for 15 years of a 22 career. He is a graduate of the University of Oxford, where he earned a Master of Science in 2024, Harvard Law School, where he earned a Master of Laws in 2006, the University of Maryland, where he earned a Juris Doctorate with honors in 1999, and the University of North Carolina, where he earned a Bachelor of Arts in 1992. He is a retired Marine Lieutenant Colonel. His military duty began as an armor officer with 2nd Tank Battalion, 2nd Marine Division. After school, he served in California, Germany, Virginia, Bosnia, Iraq, Afghanistan, Washington, D.C., which is probably his most fraught assignment, just kidding, where he was with the Atlantic Council of the United States, North Carolina, and Guantanamo Bay, Cuba. Before we turn the mic over to Butch, I would like to read the quick disclaimer that the views and opinions expressed by guests on this podcast are solely their own and do not represent the official policies, positions, or endorsements of the United States Marine Corps or any other government entity. This discussion is intended for informational purposes only and should not be construed as reflecting the official stance of any military or governmental organization. And Ryan, what do we say before we actually get started?
Well, suck it, Poindexter.
Suck it, Poindexter.
Yeah, that hasn't changed.
Exactly. So, Butch, welcome to the show. It's wonderful to have you here.
Right.
And tell
Thanks.
us a little bit more about yourself.
You know, it's funny you said that Washington, D.C. being one of my most fraught assignments. Yes, well, it's probably that way for everybody. But you mentioned the Atlantic Council, which is 1 year that I spent in D.C., which actually I want to plug them because it was one of the best years of my career. It was, instead of going to War College, the Marine Corps sends about, 25 people a year. They send, 60 or something like that to brick and mortar war colleges like National, Marine Corps War College, Naval War College, Army War College, and so forth. And so they divvy those up. But about 20 of us a year go to fellowships in lieu of War College. And that was my fellowship year. And I learned so much there. Like the idea there was, hey, go to the Atlantic Council, learn as much as you can about international policy, strategy, executive, congressional relations, how the U.S. government interacts, this whole ecosphere of policy shaping through the think tanks and through the embassies. I couldn't swing a dead cat without running into sometimes heads of state, European heads of state, not just European either. We had a Middle East center, we had a South American center, we had a South Asia center, energy center. So you get heads of state from all kinds of countries in there, but generally Europeans, secretaries of defense or their equivalent, ministers of defense, ministers of foreign affairs. Every day we had one of these heavy hitters coming in who is an international strategic actor. And so having access to them, it's a great thing. I hope the Marine Corps never discontinues that, because you give up a little something with regard to the formality of a war college, but you get this other thing in return. And it just goes into the goes into the mix of strategic level education for our officers. It was a great year.
Well, that's
So
awesome.
that was not a fraught. There are fraught assignments in DC. That was not one of them. That was a terrific assignment, and I'm forever grateful to the Marine Corps for sending me on that.
No, that's really good. And I know for the
Awesome.
show, we wanted to talk a little bit about unlawful command influence. And so I'll turn it
Yes.
over to Ryan to kind of get us started on that track.
Yeah, well, thanks for the time, Butch, and welcome to the show. I'll be honest, I was a ham-handed officer as well, thinking it was undue command influence for the longest time. And it wasn't until I was in the Inspector General realm where I realized it's, in fact, unlawful command influence. I had confluence of events during my Inspector General stint where I learned that. So tell us a little bit about UCI and what you've seen, what you've worked in, and how it kind of plays into what we're doing at the foundation, helping service members, current and former, going through administrative star chambers of justice in the military and Coast Guard.
Yeah, Star Chamber is a great way to describe it for sure, particularly with regard to UCI. UCI is pernicious. And I'm going to explain what it is. I don't fault you at all for for thinking that it was unlawful. I mean, for undue command influence, I hear that all the time. And in our prep show notes and stuff, so forth, you had that's where I'm sure you got that. It reminded you about people. I don't mind it when more junior people use that term because they don't know. But when commanders use it, when the Commandant of the Marine Corps used it, when Jim Amos during his heritage brief walked around talking about undue command influence, some friends of mine and I said to ourselves, no, it's unlawful. And it's unlawful because it's in a statute. Congress has told us this is an impermissible practice. And yet here we are not addressing it with sufficient vigor and depth. We just let this thing hang around for years and years and years. If you say it's undue command influence, that implies that there's some amount of command influence that's due, that's okay to lean in. UCI is at its essence a due process violation. It is and if we care about the Constitution, and people swear oaths to the Constitution, I swear, I just don't think that a lot of people think very deeply about what that oath means. If you swear an oath to the Constitution, you're swearing an oath to the concepts that are buried within it. And due process
Amen.
it's probably the core of the Constitution.
Amen. Amen. Thank you.
It's the number one and most important concept in the entire. It is the thing that separates us from kings.
Amen. And Butch, just throw a softball. American citizens who serve in the military, do they forfeit their constitutionally derived rights of due process?
No, they're just applying differently, right? They're applying in a different context.
Yes.
But all due process is contextual, right? There's people, you enjoy lots of due process in some contexts and less due process in others. It doesn't mean that you don't enjoy it at all. The Congress has told us so. The Constitution continues to tell us so. It is applied differently, but it isn't eradicated. It isn't just, and I've heard people say, you don't have any First Amendment rights as a military person. No, that's not true. They are just applied differently. It is a different context. There are different factors at play. There are different governmental interests, but you don't lose them altogether.
Yes. Amen to that. Thank you. Talk to us about some milestones in this UCI journey, like how the spirit began of what UCI, or I guess the prohibitions thereof on it, and how it's kind of wandered away from the initial spirit of intent of the whole thing.
I mean, it was written into law in 1950 as a means of Congress sort of rebalancing commanders' authority. During World War II, commanders enjoyed a ton of authority, and I guess that's good because we won the war. But in around 1950 is when Congress came in and said, hey, we need to rebalance things. This code, if we want people to come to the armed forces and believe that they're going to be treated fairly, to believe that they're going to be well led, even when they mess up, even when they make a mistake, even when they step outside the norms of conduct, we're not just going to throw them to the wolves into a system that absolutely gives them no rights, no fighting chance whatsoever. And so the Uniform Code of Military Justice in its 1950 version, and it's been revised a bunch of times since then. I don't have the numbers in front of me, but 60, 68, 84, there have been a bunch of big revisions since then. And about every year it changes a little bit. The Manual of Courts Martial is reissued and they tinker around the edges, but then every now and then there are big statutory changes. some of the most significant statutory changes in recent memory have been around this issue that's been lingering for 15 or 20 years now about military sexual assault, and Congress sort of wading in and trying to find the right balance between what they perceived as an underreporting problem or DoD taking sexual assault less seriously than they should. I think they got some things right and some things wrong, but that's a different show that we could have some other time. But due process is engrafted into the Uniform Code of Military Justice. Congress has told us so. This is the law of the land. And so when people swear an oath to the Constitution, they're not just swearing an oath to Article 2, the sync power and the president. They owe an equal measure of loyalty to Article 1 and also to Article 3, the courts, not the military courts, which are Article 1 courts, but the Article 3 courts. Military officers and enlisted, when they're swearing an oath to the Constitution, we distribute our loyalty equally across the branch. The loyalty is to the constitutional system of government, not to any one branch. It is very easy to default to Article 2 and to command authorities and things like that because people understand the word command. They understand how to handle that. It's more difficult for them to articulate how they're supposed to be faithful to Article 1, which is the legislature, which expresses itself through law. So when we bend the law and when we dicker around the edges of the law, when we manipulate the law, what we're really doing is being disloyal to Article 1 of the Constitution.
I had a question, Butch, and it's kind of a baselining question, right?
Sure.
So our listenership varies in rank across the services, as well as people who are not in the service. So could you describe, and these can be completely fabricated, but could you describe at the most junior level, so let's say a 03 captain level company commander, what unlawful command influence could look like there? And then that's the first scenario, just to kind of give an idea what we mean by unlawful command influence. All the way up to the second scenario is, you mentioned General Amos, the former commandant of the Marine Corps. What does unlawful command influence potentially look like there? So that way, when service members especially, or their family, are listening to stories of what service members are going through, they can say, hey, this feels, smells, walks like a duck, talks like a duck of unlawful command influence, and I think I'm going to go talk with someone about it.
Nice.
Yeah, that's a great question. So at the company level, the captain, a thing that a captain might do, so UCI doesn't really exist as a legal concept until you get to a court-martial for a special or general court-martial. Special court-martials are those courts-martial which are limited to 1 year of confinement. It's roughly equivalent in the civil system to a misdemeanor prosecution. Although we take them, there's more formality in the military system. Like we treat every special court-martial kind of like we treat it like a trial. Offenses that are disposed of in a morning in a typical city's DA, they'll drag on 6 or 9 months in the armed forces. And that's good because we give people more process. General courts martial are more like felony trials where there's unlimited punishment up to life without parole or even capital punishment, which is
really,
also
UCI doesn't come into effect until you get to that first command level of general officer or admiral. Is that what you're saying?
No, it can happen at a special court martial level too. Special court martials are generally convened by 05s and 06s in command. Okay. An 04 can be a special court martial commanding authority, but it's rare. It's generally at the battalion, squadron, ship level.
That makes
sense.
This
is a special court martial commanding authority and some 06s. There are some 06s that have general court martial commanding authority, but it's by exception. General court martials are I'm using the word generally a lot. Generally, court martials are usually convened by flag officers, general 1-star.
So then at that 05
exactly.
commander.
But there are 06s who have that command authority, but they have to be specially granted that command authority.
Okay. So what would it look like potentially at their level?
Yeah, at the captain level, it might be, there's a corporal who's on trial at a special court martial, and the captain could commit unlawful command influence himself personally by telling members within the command that if they testify on behalf of that corporal, it will look dimly on their career and maybe they won't get to go to that school that they want to, or maybe their proficiency in conduct marks might suffer. We use pro-cons in the Marine Corps. The other services have different ways of evaluating junior enlisted. But by hinting to them that if they cooperate fully in the process as a witness, if they, that their fortunes might dim as a result of pressure on their independent ability to act as a witness. At more senior levels, it can be something like a commander. One of the fact patterns that we've seen in the Marine Corps is commanders who they'll call a battalion commander, battalion formation, and then they'll allow NCIS to come and show up and then grab guys out of the ranks and then handcuff them in front of an 800 or 1,000 person battalion and march them off. Well, talk about a presumption of guilt, right? I mean, you just ruined that entire jury pool, right? How are you going to pull a members panel out of that group now when they've seen this with their own eyes and created this presumption?
Yep. Kind of like the PAO when they release statements to the wild saying such and such has been relieved, give no further information, and the person's still under investigation. Nothing's been decided yet, but just so you know, this commander's been relieved, is under investigation, and we're not going to tell you anything else. And then, oh, by the way, try to find a court-martial panel that's unbiased after reading all that. It's insane. Okay, yeah, no, that makes a lot of sense. We actually
have tremendous opinions about how little information we give with regard to relief of commanders. We can do that in another show some other time as well. That's a whole different topic, but I'm with you. You mentioned General Amos, because I mentioned General Amos. General Amos is famous for this, he's our most UCI-ish commandant ever, most likely. He gave a series of speeches when he was commandant called the Heritage Brief, and he got it in his head somehow that standards were slipping, that 15 years of war between Iraq and Afghanistan had caused people to get away from the norms of the Marine Corps, which in fact it's bizarre. Yeah, it was a really weird perception.
Reminiscent of a secretary's speech recently.
Yeah, not really. And that's what it was. So he goes on this Heritage Brief where he's going around and he's using specific case examples and talking about those cases that were pre-adjudication. And so you're the commandant of the Marine Corps, and you're talking to 186,000 people. How are you going to where are you going to find panels now that are going to ignore what he said about particular cases or about his views on particular conduct? It's impossible to unring that bell. And that's why, and it's not just commanders that can commit UCI either. Staff officers can commit UCI. One of the cases I hope we get to talk about here is a couple of lawyers committing UCI. It isn't that they are exercising command authority when they lean in on the process. It's that they're influencing the process. You don't focus on command as in commander. It's command as in the institution. The institution is leaning in on the process in some way, usually through the discrete actions of people who are acting on behalf of the government.
So let's talk about some of those milestones then, since we're on it. What were some hallmarks? We talked about kind of the morphing from 1950 to now. What are some things where we've just kind of gotten away from the initial spirit of UCI and its effects? Or
here's the thing. So I mentioned special court martials and general court martials, right? Let's use the Navy Marine Corps as an example. And don't get me wrong, this exists in all the services. It exists in the Air Force. It exists in the Coast Guard. It exists in the Army. But I'm going to use the Navy and the Marine Corps as an example because it seems to exist in spades inside the Navy and Marine Corps. UCI finds itself overrepresented in the Marine Corps. And I think there's some cultural reasons for that, some commander control obsessions, things like that, where they manipulate the process. But that's a kind of a separate issue. Above the general courts martial, every court martial, let's say in the Navy and Marine Corps, gets appealed to an intermediate court of military officers called the Navy and Marine Corps Court of Criminal Appeals. They're just regular officers, all 05s and 06s who are detailed there. Sometimes they've been trial judges before, sometimes they haven't. And they act as appellate judges. So the appeals come up to them and they issue opinions, just like an appellate court in a state, just like here in Virginia, the Court of Appeals of Virginia. Above that, in Virginia, we have the Supreme Court of Virginia. And in the military system, we have a court of 5 civilian judges who were appointed to 15-year terms called the Court of Appeals of the Armed Forces. That is essentially the highest military appellate court. Theoretically, from there, you could go to the U.S. Supreme Court, but it is really, really rare. I mean, single-digit grants of certiorari on military cases over the past 50 to 60 years. It's really almost foreclosed as an opportunity. You'd have to have a real niche issue because the U.S. Supreme Court is interested in big issues of general applicability. So they'd have to be able to lay down a rule of law from the military context that has applicability across society. That's just pretty rare. So essentially, CAF becomes your court of last resort. If you went and tallied all of the UCI cases out of CAF over the past 50 or 60 years, you would see the Marine Corps pretty overly represented in CAF cases that find UCI relative to its size. I mean, the Marine Corps is less than half the size of the Navy. It's probably about half the size of the Air Force and maybe a third of the size of the Army. But the UCI numbers are up there competing with each one of those services. So per capita, the Marine Corps is pretty overrepresented in UCI. And so that's how it bubbles up. CAF has issued case after case after case, and they can hardly use stronger language when they're communicating. We indulge in this legal fiction that when courts talk, that people are listening. And I think generally that's true. When SCOTUS Supreme Court issues a case, the rest of society says, okay, that's the new rule of law. And they apply this case and they adjust their practices in tax cases, in antitrust cases, in criminal law. When the court tells us they lay down a new rule and society applies it. When CAF talks about UCI, it seems to me sometimes the services are like, oh, that's interesting. We're not changing anything. And so it doesn't really, you see the same issues bubble up over and over and over again. You see CAF smacking the services down just as hard as they possibly can. And yet we don't adjust our training enough. We don't adjust our practices enough. We don't hold our judges and our prosecutors to a high enough standard with regard to this. We just sort of treat CAF as we treat those cases as one-offs and go, well, we lost that one, but it doesn't really change the culture of the way that they apply.
So what's the recourse? Let's use a hypothetical. The only crossover I had from my time in the military with UCI was, oddly enough, I was working as a translator it was in a rape case in Germany. The alleged victim was a German local and the perpetrator was an airman. So I sat through the case, and at the time, this was circa 2013, 2014, there was a blanket, and I'm going to get the semantics wrong here. There's like blanket UCI because of the words from, I think it was President Obama had said something to the effect of, we're going to prosecute offenders to the max, something where it crossed the line, right?
Yeah.
So what's the recourse, though, when something like someone in a position, a secretary or the commandant or what have you, crosses that line? How do you walk that back?
Yeah. So what prosecutors will do is judges will give additional peremptory challenges on the panel. So you can, or they'll expand the ability to voir dire panel members to see if they can really be fair. So I can tell you, if you put me on a panel, I never served on a court-martial panel. It's hard for lawyers to get detailed to court-martial panels for obvious reasons. But if I had served on a court-martial panel and a prosecutor or defense counsel asked me, did you hear what President X, because this has been a bipartisan issue, it's been the Democrats have overstepped, Republican leadership has overstepped. This is not a one-party issue at all. So let's say they said, President X, you said this thing about these kinds of cases, and he has his expectation that sexual assault cases are going to be handled this way. And that expectation was not consistent with the law, or it was an overstatement of the law, it was some bending of the law. And they would ask me, despite that statement, do you believe that you could be objective and fair in this case? I'm looking at you and I'm swearing to you, and if I had a Bible here or any holy book, I could put my hand on it, I could tell you that would not affect me one bit. I would just set it aside. I would just go, you overstepped, but that's not my role here. My role here is to be a fair and objective panel member and to vote for guilt if the evidence meets the standard of proof, and to vote for acquittal if it does not. That is my role, and that is my duty-bound role. Not everyone can do that. So they would challenge people and they would go, how does that make you feel? And if a person came back and said, well, it's the commander in chief, he's basically telling us how he wants things handled, that person would be struck. So what they would do is they would go through this voir dire process. And it works a lot like it does on television. If you've watched The Lincoln Lawyer and the voir dires that go through the jury selection in those cases, they're trying to get at what are those factors that would keep a person from being reasonably fair in the case. I can tell you that wouldn't affect me. I can also tell you there are people that would affect. If there was a person on the jury who, on a panel, who leaned MAGA and President Trump set out an expectation, you would really need to drill down on that to explore whether that would affect his ability to be fair. And again, I'm not picking on one side or the other. This is an equal opportunity screw up.
So there's mitigations at where the rubber meets the road, so to speak. But it's reminiscent of it was Secretary Del Toro a few years ago who violated the Hatch Act, and he was out campaigning for President Biden in effect, and they said, "You have violated the Hatch Act. This has been sent to the White House for address." It was comical, but in the same vein, what's the recourse? Where's the accountability for people who are violating
Yeah.
or stepping over the boundaries and making these, bending the law, torquing the law, twisting the law as a leader when they're making statements? How are
Yeah.
they held to account? Because you can't unhear what you've heard.
That's right. If I were a legal advisor to a commander who overstepped in that way, or let's say I was a legal advisor to a three-star commander and the president came out and said, I would ask my commander to make a statement that says, hey, I heard what he said. Here's how we're still committed to a fair process. There's things that a commander can do to walk back, or if a commander says something unwise himself. Yeah, so the commander can try to unring that bell by making statements that kind of undo the damage or take the sting out of the thing that he or she initially said. And in the appellate, and so all that stuff goes into their record. If you're a legal advisor advising your commander on how to unring that bell, you might take several steps. You might have him do it at several different occasions. Maybe he would issue a written statement. Maybe he would talk to all the sergeants major and say, listen, Sergeant Major, get in here, get to the club. I'm going to address all of you now. And he would tell the Sergeant Major, and he might tell the commanders separately. And he might show up at a division run and say, I want you to know that I'm committed to treating you fairly, that it's really important that you not get the perception that if you do get in trouble, that you're gonna, there's things you can do to take this sting out of it. And the question is, once you put all those things together and they put it into an appellate record, the judges will say, yes, this was effective, or no, this was not effective. If you combine that with deeper voir dire and a bigger members panel, you might be able to unring that bell. But ultimately, what the courts can do is, if they're not convinced that the government has done enough to unring the bell and that it has infected the fairness of a proceeding, they can dismiss the case either without prejudice, which means the government has to decide whether to do it over again, or they can dismiss it with prejudice. And they've done that. The CAF has shown its irritation with this issue by, you hear this criticism, well, the remedy was too extreme. The CAF didn't need to dismiss this case with prejudice. But that's within their kind of inherent judicial power. They're sending a signal. You're losing this case forever because we dismiss with prejudice. You can't bring it back. It's done. Oh, and by the way, when you do that with an E7 and he's been reduced, you have to restore him back to that rank. He's now probably retirement eligible and back pay for all the pay that he missed when you're basically pretending like it never happened. He gets a big payment of back pay and so forth. There's all these corollary effects that come out of this thing. So CAF has expressed its irritation by killing some cases permanently. The services should be taking that and saying, this is bad. We lost a really important case here because of things that we can control, things that we can change our own training and change the discipline of our commanders, taking this issue seriously. I am convinced, this is more than you asked, but I'm convinced. Commander generally has a 2-year window of command, right? His number one priority is getting that unit to do the things that he needs it to do so that it reflects success on him. He is not invested in the long-term health of this system, but service chiefs have to be. And so you're not going to solve this issue at the 05 and 06 level because they are incentivized to maximize their own authority and to walk right up to the line. You are never going to get those people to self-constrain. So it falls to the service chief to say, no, guys, I'm serious. We're going to rebalance the scales here. Our training is going to be more effective. You need to understand that if we care about the Constitution, we care about all of it, right? And we care about the due process pieces of the Constitution. We care about all of it. We care about the free expression pieces of the Constitution. We care about the religious accommodation pieces of the Constitution. So, for example, the Sikhs with their beards, it is not a big concession to make to allow them to. It frightens people. It makes them think this guy doesn't look like a soldier in 1975. Well, yeah, that's right. He doesn't. But if you've ever known any Sikh officers, their culture is one of incredible devotion to duty and incredible self-discipline. We should be lucky that Sikhs want to serve in the armed forces, and we should accommodate.
I think we could diatribe off on that topic for
Whole
another
different
episode
topic.
as well.
Yeah.
Well, you don't look or think like me, so you can't serve honorably.
Right. Exactly. It's a whole thing.
Anyway, let's talk about something you talked about, looking at the whole picture in the entire spectrum. We've talked so far a lot about Uniform Code of Military Justice and courts martial, etc. It's interesting because very prevalent in our work right now is this idea of the chilling effect as it pertains to restriction. For example, when a secretary says all complainants are just low performing ideologues, as an example, is there a crossover there? Can UCI bleed into administrative regimes?
For sure it can. For sure it can. We just don't call it UCI, but it's the same thing. It's very difficult to operationalize UCI in an administrative context because we have a legal framework for dealing with it in courts martial that really just kind of doesn't exist over in the administrative. You have to basically make the same arguments, but if you call it UCI, people will go, this isn't a judicial proceeding. UCI doesn't apply. So you have to describe the same concept in terms of fairness. The way that you get relief in an administrative proceeding that has been infected by something like UCI is you basically have to sue the government. You have to sue the government, as opposed to a court martial where you've got a venue provided for you by the government and the expenses are generally carried by the government, unless you hire your civilian attorney, which are expensive, but sometimes really worth their weight in gold. Like if a civilian attorney costs you $75,000, but you're fighting a case where the potential penalty is life without parole, and your detail counsel is a captain who's been been a lawyer in the service for three years.
Yeah,
you're probably going to want to reach for some deep experience there and pony up and just spend the money. But I digress. If in an administrative concept, the exact same leaning in, I call it, or manipulation of the process can exist in an administrative proceeding, but you don't have a forum to really adjudicate it. The way you do it is at your own expense after the thing is done. If you get, thrown out at year 12 or something like that, and UCI, an administrative proceeding, like a board of inquiry or something like that, you get invited to leave the service early and you get an OTH or something like that. The only way to really attack that is by suing the government after the fact. It's messy, it's expensive, it's very, very difficult. And we don't have enough protections in the process against that. There should be protections inside processes that exist on their own as an element of fairness. These justice systems, these administrative systems, they cannot just be about maximizing government authority. They have to be about the government applying its authority in responsible ways while creating the impression among the force that they're going to be treated fairly. I care about being treated fairly. I care if I'm a dad. I've got 2 kids in the armed forces right now. I got a daughter who's on a Navy ship on the West Coast, and I got a son that's in a Marine battalion on the West Coast. It's just about to deploy. I care about if I got a son who's a corporal in the Marine Corps, or a daughter who's an airman in the Air Force or something like that, I care that they're going to be treated fairly. And by treated fairly, I mean, if they step out, if they get in a little trouble, it doesn't mean they're bad people. It means that they're young and sometimes they make mistakes. But the process should treat them fairly. The process should not just throw them in the meat grinder and chew them up, but rather they should have an ability to leverage a fair process and come out of it on the other side, take their lumps and get on with it. But we treat everything like we have to maximize all authority and just crush people all the time.
Yeah.
That's not a responsible way to administer the system.
No.
Fairness matters.
Yes, I agree. In one of your Marine Corps, I believe Jason Wareham was a former Marine Corps as well. One of your former Bulldogs, we had him on the show a few months ago. He said that exact same thing is we need to be showing some grace for the 1% who raise their hand and volunteer to serve, not just invent more machinations to crush them, right? But
and that
to your point,
it doesn't mean lowering the standards, right?
No,
That's not what we're talking about. We're not talking about lowering the standards. We're talking about giving them a fighting chance.
Exactly. It's only due, as in the Constitution. Yeah. So we talked about, again, legal avenues of redress, and then in the administrative realm, the cost and time prohibitive maneuver of suing the government if you weren't in the service, because otherwise you'd be barred by ferries. So I argue, and I'm interested to hear your thoughts, is that we should and do already have some sort of mechanism that should be providing the checks and balances on the administrative form of unlawful command influence, and that's the Inspector General system. When you have a commander exert undue, unlawful, just authorities outside their bounds, like reprisal, retaliation, restriction, etc., we have, in theory, this entity that you should go to, and they should provide the checks and balances, but it's not happening. What's going on?
So I'm gonna be fair and unfair to them at the same time. So to be fair, they are crushed by the workload. People, I mean, it is so easy to file an IG complaint. You sit down on your computer, 15 minutes later, you vomit out how you think you've been treated unfairly. You press send, and now this is something that's going to take hours for someone to look into and screen it and see if there's anything there and unwind it. The amount of work versus the resources we give the IGs is just disproportionate. So they have to marshal their resources about the cases that they think are really, really important and really have an effect on the department. And very often one of their reactions is, hey, you've got a process for this. You need to push that over there. This doesn't fall within the IG's mission. It also is about how the IG sets the tone, the IG for the service, for the DoD, how they set the tone about what it is that they'll entertain, what they think they have space to entertain, how narrowly or widely they construe their authority, right? If an IG says fraud, waste, or abuse, if someone is being abused in an administrative process and they're not being accorded, if all of the deck is totally stacked against them and they don't have a fighting chance, I would see that as abuse that ought to be of the type that you'd have some remedy, you'd have some advocate. The IGs, either because of workload or because they don't believe that's their core mission, that they think that, and to be fair, they're looking at multi-billion-dollar procurements for procurement fraud. They're looking at really big things, that major muscle movements within a department. So an E3's, administrative separation board is probably not going to make the cut. That's unfortunate because that E3 is really, really doesn't have once that ball starts rolling, it's really hard to unroll it, to stop it from rolling. And the IG is just, it's bandwidth plus culture plus like an avoidance doctrine, right? It's like they're like, this isn't our core job. We don't have this. It's a combination of avoidance and bandwidth and all these things, and it's just not an effective mechanism for that kind of thing.
Yeah, it's really,
maybe we need a tiered IG system, right? So for
Yes.
low-hanging fruit, that you have an IG system that works at up to this level. And then for medium importance cases, you have IGs that work at this level. And then for, multi-million-dollar procurement frauds like, Fat Leonard and things like that, it works at this level,
Good point. One of the many points that you hit on there, Butch, was the bandwidth. And really, the DoD IG office itself is really quite small and really pretty much a glorified audit agency. And
Yep.
That's fine, and that's their bailiwick. Unfortunately, or fortunately, fair but unfair, however you want to say it, I think you phrased it very well, is that there is an operational chain of command, so to speak, and a lot of people don't realize this. And it was funny when Francesca was talking and briefing the DoD IG staff, now coming up on 2 years, they were very adamant about the fact that service IGs do not work for the Department of Defense Inspector General, which is mostly true. However, then you ask, where do all reprisal and restriction complaints go to for review and final approval? It's the DoD IG. So there's this want of separation, and I get that. And there's the IG Act, which doesn't necessarily apply to service IGs in Title 10, but the services have now structured, and exactly how you talked to a few segments ago, the IG within the services have just become another arm of command influence, and I argue that needs to change.
Yeah, I mean, I would love to see some more independence. There should be some statutory reform that they give them more independence. I think that if you look government-wide, you see some IGs out there that are it's a combination of their authorities and culture and the individual strength of personality of the IG. If you're an IG, you can go out there and say, no, I'm the IG. I've been charged by Congress with doing these things, and I'm going to do whatever, I dare you to try to fire me over it.
Right.
If you have an IG like that, they can be an absolute force multiplier for the senior level leadership to really root out some of the bad things that are happening inside their organization. Again, there's this short term versus long term. It takes a transcendent strategic leader to really be worried about the health of an organization. If you're a service secretary, you're in that job between 18 months and 4 years. Rarely does it go. Let's say your president gets reelected, maybe you stay a fifth year or something like that. It is super rare to stay 8 years. The 8 years that would be required for you to take a real long-term view of the health. No matter what, your term is finite. So people are incentivized to generate good outcomes during their truncated term rather than really, it takes a transcendent leader to be thinking about worrying about something 20 years from now in terms of the health of the system when you know you're going to be there 3 years, right? It's much more, they're much more incentivized to generate really good results within my 3 years so they can walk away with their gold watch and they can dust their hands and say, I did a good job for the 3 years that I was there, even though they may not have addressed some problems that are going to manifest 10 years later.
Yep. I agree. So segue to that, and then I'll pitch it to Francesca for the final words. I'll leave this last question, a hypothetical. Butch, you're king for the day, and you can change whatever within reason. What's going on in our military? What is one or a few things you think are doable in that short time frame that would make strides into addressing the UCI issue or
Yeah.
the UCI-like issue in the administrative realm?
Yeah, we need statutory reform of UCI. It needs to be more than just Court of Appeals for the Armed Forces, screaming into the wind to services who aren't really taking them seriously. For your listeners that are out there, we didn't really get to it here but from the show notes. There's 4 cases that I want you to look up if you're curious about this issue. And I'm going to tell you the names of the 4 cases right now. They're Chessani, Chessani. That was a lieutenant colonel, battalion commander during the Haditha conflict, who got his case dismissed because a Marine colonel, staff judge advocate, really, he did some things he should have known better than to do and kind of screwed up the entire case. Second one is U.S. versus Chamblin, Chamblin. And the two that really stick in my craw, a case called U.S. versus Gilmet, Gilmet. Gilmet was a Navy SEAL chief who was accused of sexual assault, and Navy JAG leadership at the 2- and 3-star level manipulated his case in order to leave him. They hung him out to dry. For the life of me, I don't know why SEALs everywhere aren't just beside themselves over this. They've kind of left. They should be the things that, if you read the Gilmet case, if you just go Google Gilmet, Court of Appeals for the Armed Forces, and just read the case, you don't need to be a lawyer to understand. You can read if you can stick with that case and read it. They do a really good job of laying out how the miscarriage of justice that happened to Gilmet. He got screwed. Ultimately, his case got dismissed with prejudice, but CAF was like, yeah, this is outrageous conduct by flag officer lawyers, one of them who wound up retiring as a 3-star anyway. He should have been held accountable. He should have been retired at a lower grade. But instead, he's right there in a legal opinion, calling this guy out, and the department just lets him retire. He's president of a college down in Texas somewhere now, right now, living the good life. He deliberately tried to screw Chief Gilmet, and because of political pressure over sexual assault coming from the Hill, and he escaped with his 3-star pension, and now he's living his best life down as these things. There's never any accountability for these guys. And the last one is a case called, I'm sorry, that was Barry. I was describing Barry. The 4th case is a case called Gilmet. Gilmet I'm sorry, I got this confused. That was Barry, and Gilmet is the case that came out of Iraq in Kurdistan. That was a accidental homicide where a Marine lawyer basically attempted to intimidate a bunch of Marine Defense Counsel, and that case got dismissed with prejudice as well. He retired as an 06. There was never any professional responsibility. The professional responsibility process never holds any of these people accountable. That's another thing. So we need statutory reform in terms of UCI and training. We need greater accountability over the people who actually committed. When you commit UCI, you're breaking the law. That's why it's called unlawful command influence. You're breaking the law, and these people just walk away from the consequences like it never happened. So for the lawyers, we need greater professional responsibility. We need to relook at that system, maybe take some of the discretion away from the military, invest it in separate civilian authorities that aren't accountable to the chain of command.
That's actually a perfect tie-in, Butch, to the question slash pondering I was going to ask you, but really it's the question is what's the why? So you said that CAF, the services do not listen to CAF in any sort of meaningful way. And you also had mentioned earlier that UCI as a concept first came about in 1950, which coincidentally is the same year that the Supreme Court decided the Ferris case, which in essence the precluded the ability of service members to seek any sort of recovery or any sort of external check on the system of the executive branch. It took the judicial branch out of question in any sort of meaningful way. And so the question that I have for you is what, given Ferris and given the Supreme Court's continued resistance to change Ferris and given Congress's continued resistance to open up the Federal Tort Claims Act so service members can use it, what could possibly be done in order to make it so that the services will listen to CAF and not always defer to essentially the people who are committing the UCI, which is the people who are writing their performance evaluations. So why would I bother listening to the CAF if CAF's not writing my performance evaluations? The commander who's committing UCI. So
Yeah.
what could
Where's the incentive?
possibly be done to try to resolve that inherent systemic issue within the DoD and the Coast Guard?
There's 2 points to make there. One is, so Ferris is a Supreme Court invented doctrine that prevents service members from suing. It basically creates an exception to the Federal Tort Claims Act out of whole cloth. There's a reason it exists, right? If you are operated on in a field hospital in some remote area and a doctor has to make a quick call and he does something and medically it wasn't exactly the right thing to do, but he had constrained resources and people were actually shooting at the field hospital and things like that, we should not allow the kid to sue that. That is a risk incident to service. And so Ferris kind of looks at the worst case situations where we don't, and it basically draws a huge line around all cases. I think med mal in Balboa Naval Hospital, which is a hospital that rivals any inside the United States, is a totally different issue. If you hate, let's just say for some of your conservative listeners, if they hated Roe versus Wade and the criticism that it was completely judicially created, right? And that is the criticism of Roe versus Wade, was that it was completely made up by the Supreme Court. And as a matter of law, it's not wrong. I liked the outcome of Roe, but it's not wrong. The criticism of the opinion is well-founded legally. If you hate Roe versus Wade, you should also hate Ferris, because it is the Supreme Court just making stuff up that theoretically ought to be the province of Congress to do, which leads into my second point on this. There's no substitute for the Congress. There's just no substitute. If they don't get immersed in these issues, nothing will ever happen. If I were a senator on the Senate Armed Services Committee, I would be very interested in the UCI record of 1 stars who want to become 2 stars. And I'd be very interested in the UCI record of 2 stars who want to become 3 stars. We need to kill a handful of these promotions and nominations in order to get people's attention. This issue matters. When your nomination from 3 star to 4 star goes before the SASC and you're individually confirmed, if there's stuff in your record about UCI, we're going to explore that. And if I were a senator on the SASC, I'd be looking at promotion holes over issues like that. You will not get these people's attention until, one, you pass some law that mandates training to specific standards, not just big, but to specific expert standards. And two, you make it painful for these people to ignore the problem. They only understand one thing, and that's their own advancement. So you need to curtail their advancement. They need to stop allowing DOD to retire people like the Admiral in the Barry case. This guy, he went out and manipulated the process to screw Navy SEAL Chief Barry. It's in the record. Read the case. You cannot believe what he did to this guy. And he still retires as a 3-star. Arguably, he should have been retired as a 1-star if you apply the last grade satisfactorily held standard, because he committed the misconduct as a 2-star. Well, then he's not serving satisfactorily as a 2-star, so therefore he could never serve satisfactorily as a 3-star. Arguably, he should have been retired as a 1-star, but he skates. He skates out because nobody takes a good hard look at that. Maybe we need some new statutory language on that kind of stuff as well. We need a more robust review process of our retirement grade eligibility.
I love it. Yeah, it's a perfect end of the show there, Butch. I agree. There are really only a few junctures at which our Congress right now should, and by letter of the law, can get involved in military affairs. First is the NDAA, the National Defense Authorization Act process, where the budget goes to them. And the other one is the nomination process. And that's the two real points right now that exist where they could inject a little reality check, and many times sadly don't. So I like your idea, I like where you're going with that. I want to say thanks for your time. Thanks. We had a lot covered there, and it was a very concentrated can of orange juice there that we covered. And for all the listeners, you got a little homework too. You got some reading to do. But thank you very much for the time. And Cheska, you to finish.
Oh, thank you so much, Butch. Really appreciate it. And we will include, if you could send us the links to those cases that you mentioned, we can put those into the description of the podcast when we post it.
Great.
So
Right. Yeah, I won't make it easy. I won't make it easy for people to read those decisions and see for themselves. I'm not just making it up. If they read Gilman and Barry, and these things escape people's notice because they're relatively obscure until people like you put it out to them in plain language, right? But you don't need to be a lawyer to read Barry and Gilman, for example, and to see how it screwed these. I mean, these are career service members just got thrown into the wood chipper because it was politically expedient. Yeah, I'll send you those links to each of the 4 cases. People can read them themselves, and they can know we're not just making this up. It's right there in black and white, and it's hanging out there. It's a hanging curveball, to use our baseball and World Baseball Classic and Cubbies analogy, is a hanging curveball waiting for the Armed Services Committees to take a swing. If they're interested in the fairness, if they're interested in the perceptions of America's fathers and mothers sending their kids to serve in systems that are fundamentally unfair, UCI would be a great place to start ringing the bell.
All right, great. Thanks so much, Butch. Have a great week. And thank you so much for coming on the show. It's been just a pleasure to host you here.
All right.
Yeah, thanks for having me. This was fun. We can find another topic and we'll do it again.
I
think we found 6 new ones during this show.
Yeah. All right. Thanks, Butch. Have a great week. Bye. Well, that's it for this week's topic. We really appreciate you tuning in. Don't forget to hit that subscribe button if you haven't already, and check out our foundation website at walkthetalkfoundation.org.
And feel free to reach out and give us feedback. You can get a hold of us via Facebook, X, Instagram, LinkedIn, and our foundation's website. Details in the description section. Thanks for tuning in, and see you next episode.